And it's an attempt to really maybe get a small piece or some piece of their life back. And so it's a task that requires not only skill, but compassion. Hello again, it's Lana Manitta from Rossen Law Firm, and I'm going to talk today about the First Step Act, which seems to cause a lot of confusion for clients and attorneys alike. Before I get started, remember to like and comment on this video. Let us know what topics you're interested in and subscribe to our channel. We have a variety of videos on criminal defense topics, and we update them all the time. So, the first step is actually, because the feds love acronyms, the Formerly Incarcerated Re-Enter Society Transformed Safely Transitioning Every Person Act. It's a pretty broad statute. It's aimed at prison reform, and it does, among other things, it does the following. It calls for there to be risk of recidivism studies to be done on inmates, and for the creation of programming that will help inmates either gain privileges or earn time off their sentences, or both. There's a big caveat, because there are over 70 offenses that will not qualify for additional reductions of their sentence, and anybody with a removal detainer from ICE also would not qualify. And unfortunately, those 70 offenses and ICE detainers make up a pretty large population of inmates in the Bureau of Prisons. The First Step Act also expands application of the so-called safety valve, which is a provision that allows for defendants with minimal criminal histories to escape through the safety valve, as it were, mandatory minimums in certain offenses if they meet a number of criteria, which I'll go into in another video. The act also retroactively applied the adjustment for what was once an unbelievably large disparity in sentencing between crack cocaine and powder cocaine. But perhaps the most impactful part of the legislation, at least in the day-to-day practice for a federal criminal defense attorney, is the opportunity for inmates to seek compassionate release. The First Step Act, it provides a number of grounds for this, but the most important is the catch-all phrase of extraordinary and compelling grounds. Now, what are extraordinary and compelling grounds? Well, in the few years that this legislation has been in place, we only have examples of what have not really been considered extraordinary and compelling, and very few that have fit the bill. But the good news is that it's not really clearly defined, and so it's not really clearly limited. There hasn't been, Supreme Court case law telling us this is and this is not extraordinary and compelling, and giving us a set list from which we have to work. And so right now, the playing field is pretty wide open for us to make attempts to file motions on our client's behalf, alleging a wide variety, almost as wide as your imagination, of what is extraordinary and compelling. And of course, as defense attorneys, we find many, many reasons to let somebody out early to be extraordinary and compelling. And just because the court may not agree doesn't mean it's not worth a try. So, according to the United States Sentencing Commission, as of March of this year, and this is 2024 that I'm filming this, over 32,000 motions had been filed for compassionate release, and only 16% had been granted. But for the second quarter of 2024, that percentage went up to 17.7%. So that is hopefully good news. Grounds for the motions that have been filed include everything from age, illness, including COVID-19, which made up a large percentage of the early motions, to challenges even to the fairness of the original sentence. But the most often cited reason for granting compassionate release was rehabilitation. However, in every case where rehabilitation was listed as a reason, other reasons were also listed for granting compassionate release. And so what this means is compassionate release is not being granted solely on grounds of extraordinary rehabilitation. There needs to be something else, at least statistically speaking, so far. The other reasons that were most often cited, the second and third most cited reasons for granting compassionate release, were serious illness and terminal illness. Unusually long sentences were the fourth most cited reason, but these were usually coupled with a change in the law, such as the changes to sentencing on multiple 924C counts or the disparity in the crack and powder cocaine sentences. And so, in these instances, ridiculously long sentences had been imposed. There had been changes in the law. And now we were addressing this with a compassionate release motion. Especially were reductions associated with what used to be the stacking of 924C counts. 924C charges are charges of having or possessing or using a firearm in connection or during and in furtherance of drug trafficking, depending what subsection of 924C that you're charged or convicted under. And these have mandatory minimums associated with them. And then if there were multiple firearms or second and subsequent offenses, they would have longer mandatory minimums. And because they had to run consecutive, they would run consecutive to each other. And as you might imagine, in cases where there were multiple firearms, people could be getting decades for, having more than one or more than a few firearms associated with, for instance, a drug conspiracy, having them present in the so-called trap house or in their homes where they were keeping drugs. And so, that was one of the areas where we saw reductions, but that was a really significant change in the law that was also part of the First Step Act that informed a lot of these compassionate release reductions. So while 56% of compassionate release motions mentioned rehabilitation, only half of those were partially or all based on long sentences. So the takeaway is that by and large, someone who is very sick or dying and actively engaged in their rehabilitation while in prison has the best chance of compassionate release, and not somebody who has actively engaged in rehabilitation but has a long sentence for which there has not been a relevant change in the law. So this isn't great news, but this is fairly new legislation. And our judges, frankly, aren't used to letting people out of jail. And so I still think there's a lot of room to make good law under the First Step Act and compassionate release. Now, most federal defense attorneys that I know, and I've been doing this for 26 years, have filed many of these motions and have had one or two granted. And we all see a win on one of these as a really big deal because, as I told you, 16%, that's a really low percentage, 32,000 plus motions filed, 16% granted. And a lot of those were from illnesses that arose out of COVID-19 infections and people who were really doing very, very poorly or had chronic illnesses that were going to make them more susceptible not only to infection but death if they did become infected with COVID-19. So, but the drive is there, and it ought to be there if you're looking for an attorney to do a compassionate release motion. The attorney needs to be somebody who is not discouraged by how low the statistics are, but rather feels that lights a fire under them to try even harder and be able to kind of tally up something, a notch on their bedpost, so to speak, and be able to brag to the other lawyers, hey, I got one. If your attorney is discouraged by these statistics, you need to find somebody who really is just inspired to do more and do better because so few of these have been granted. That's what you want in a criminal defense attorney at any phase of your case. But with compassionate release as well. And keep in mind, compassionate release is filed for a client usually well after they've gone to prison, and maybe even for a person who wasn't your client at trial or even at the appellate level. And it may be somebody that you're never going to meet in person if they're housed across the country and family hires you, and maybe you have one or two arranged attorney-client phone calls while you're working on this motion, but mainly you're looking at the prison records, you're looking at the underlying case, pre-sentence report, sentencing memos, maybe even the sentencing transcript to see what the allocution was about or comments that the judge might have made about the sentence that was being opposed. This is not a case that you were involved in at that phase, but you really have to immerse yourself in the case nonetheless. You're rehashing the offense conduct. You're going back over the life circumstances of your client and everything. In addition to all that, everything that's happened in prison, the good and the bad. I mean, this is an undertaking that cannot be done with a form motion or given less attention than your other criminal defense work. It is fighting for someone's life just like a trial, just like a habeas, just like an appeal, just like a negotiation with the prosecutor. And it's an attempt to really maybe get a small piece or some piece of their life back. And so it's a task that requires not only skill, but compassion. And, we at Rossen Law Firm, we pride ourselves on helping good people when bad things happen. And, being in prison is one of the worst things that can happen, but it happens to good people. And the attorneys here that do federal defense have an abundance of skill and compassion. And we are able to apply these attributes to assist family members in retaining counsel, to submit compassionate release motions for their loved ones who are incarcerated in the Bureau of Prisons. So if you know somebody or are related to somebody or care about somebody who is in the Bureau of Prisons and who knows, might have extraordinary and compelling reasons for seeking early release, then please call Rossen Law Firm or refer them to us. Now, that's all for today on the First Step Act. It's a longer and more complicated body of legislation than I've let on here, but that could be the subject of a number of additional videos. So remember to like and comment. Let us know what else you'd like to learn about. Subscribe to our channel, and thanks for watching.